Imagine this. A seemingly peaceful journey through international waters suddenly becomes deadly. It sparks a huge diplomatic crisis, and the whole thing lands in, well, the highest court in the world. Welcome to the deep dive. Today, we've got our hands on the actual court documents, a big stack of them, from a truly landmark case in international law. We're talking about the International Court of Justice's 1949 judgment on the Corfu Channel case. And our job, our mission today, is to pull out the absolute key takeaways for you. We want to help you understand what really went down in the Corfu Channel back in 1946, why it was such a big deal then, and honestly why it's still a foundation stone of international law today. Because this isn't just about, ships hitting mines. It goes much deeper. It's about sovereignty, state responsibility, and really the nature of justice between nations. Okay, so let's get into it. What exactly happened on October 22nd, 1946 in the North Corfu Strait? Set the scene for us.
Right. So on that day, you had a squadron of British Royal Navy warships. Two destroyers, the Saumarez and the Volage, were leading the way. They were sailing north through this channel, the North Corfu Strait. And importantly, this channel had been swept for mines before, back in 44 and 45, and was generally considered safe passage.
Considered safe, but clearly wasn't.
Tragically, no. Just as they were outside the Bay of Saranda, the Saumarez struck a mine. Massive damage. Then, as the Volage moved in to help, maybe try and tow the Saumarez, it also hit a mine. It was severely damaged too, but somehow managed to tow the Saumarez back towards Corfu. The human cost was terrible. 44 British officers and sailors were killed or injured.
Just devastating. And these explosions, they weren't accidental equipment failures or something. What did the court actually determine was the cause?
No, not accidental. About 3 weeks later, mid-November, the British Navy sent minesweepers back to that exact area. Operation Retail, they called it. And they found them. 22 moored mines, German GUI-type mines, laid out in the channel. The court looked really closely at all the evidence, the type of damage to the ships, the location, everything. And their conclusion was unequivocal. The explosions on October 22nd were caused by mines from this specific newly laid minefield.
A newly laid minefield. Okay, so that leads directly to the first huge question the International Court of Justice, the ICJ, had to tackle, right? Was Albania responsible for these mines being there, for the explosions? If they were, did Albania owe compensation for the damage and loss of life?
Exactly. That was the core of the UK's initial claim. First, the UK argued that Albania itself must have laid the mines, or perhaps they worked with another state specifically. They pointed the finger at Yugoslavia to lay them.
Albania itself, do they even have the capability?
Well, that was a key point. Albania stated it didn't really have a navy to speak of, which made direct involvement less likely. The court ultimately found there wasn't substantial evidence to prove Albania physically laid those mines.
Okay, so what about the Yugoslavia connection? That sounds intriguing, like some kind of Cold War plot precursor.
It does, doesn't it? The UK brought forward a witness who claimed they saw mines being loaded onto Yugoslav warships around that time. But the court looked at this testimony and basically said, look, one person's account isn't enough. It's not decisive legal proof for what they called a charge of exceptional gravity against a state.
A high bar for proof then.
A very high bar. And this is important, The ICJ was saying you can't just accuse a country of something this serious based on shaky evidence. Even other bits, like Yugoslavia maybe having those types of mines or being politically close to Albania, the court said it was all just too circumstantial, inconclusive. So in the end, the court actually stated quite plainly that the authors of the mine laying remain unknown.
Wow. Okay, so if Albania didn't lay the mines, and they couldn't prove Yugoslavia did, how on earth could Albania be held responsible? This is where it gets really interesting legally, isn't it?
It really is, because the UK's argument shifted. It became less about who laid the mines and more about what Albania knew. And here's where the court laid down a really crucial principle. They said, okay, just because a state controls its territory, that doesn't automatically mean it knows about every single illegal thing happening there. But that control does allow the court to use what they called a liberal recourse to inferences of fact and circumstantial evidence. Basically, they can draw strong conclusions based on the surrounding facts. The condition, though, was critical. These inferences, these conclusions drawn from the circumstances had to leave no room for reasonable doubt.
So they could use circumstantial evidence, but it had to be incredibly convincing. What kind of evidence did they look at?
They focused on two main sets of facts that seemed to point in the same direction. First, Albania's behavior before the incident. After May 1946, Albania was keeping a really close watch over the North Corfu Channel. We know this from diplomatic notes, where they were demanding ships get permission to pass. And there were previous incidents. Remember, Albanian shore batteries had actually fired on British cruisers, the Orion and Superb, back in May 46.
Right, so they were definitely monitoring that strait closely.
Exactly. So the court thought, given this heightened vigilance and the fact that the minefield was clearly recently laid during this exact period, well, Albania claiming complete ignorance seemed, as the court put it, somewhat improbable.
Okay, that makes sense.
Wow. The other telling thing was Albania's reaction after the minefield was discovered by the British on November 13th. Albania sent off these angry telegrams to the UN, protesting the British minesweeping operation in their waters. Which, okay, you might expect. But here's the thing. In those protests, they never once mentioned or protested the existence of the actual minefield itself. They complained about the sweeping, but not the deadly mines found in their own territory.
That is strange. What did the court make of that silence?
The court suggested it might indicate Albania desired the circumstances of the operation to remain secret. It strongly hinted at knowledge, didn't it? If you didn't know about the mines, wouldn't your first reaction be shock and outrage about them being there?
Good point. So vigilance beforehand, strange silence afterwards. Was there a second line of evidence, too?
Yes, and this one was more practical, almost physical. It was about the simple feasibility of spotting a mine-laying operation from the Albanian coast. Geographically, that part of the channel is very close to the shore, and there are high points overlooking it. It's an area that's easily watched, as the court said.
So could someone have seen it happening?
The experts crunched the numbers. They figured laying that kind of minefield would take probably 2, maybe 2.5 hours. Long enough, they thought, to attract attention from shore lookouts. And they didn't just theorize. The court actually had experts conduct a real one-old test.
Seriously? A visibility test?
Yes. They did it near St. George's Monastery on the coast. They wanted to see how visible a ship would be at night. And even under conditions designed to be difficult, a blacked-out ship, no moon, the test ship was clearly seen and heard from the shore at quite a distance. So the experts reported back to the court. It was indisputable that if Albania had kept normal coastal lookouts, the mine-laying operation must have been noticed.
Wow. So combining the close watch, the weird silence afterwards, and the fact that it should have been observable, what did this all add up to for Albania's responsibility?
It added up to a conclusion based on all these consistent clues, these concordant inferences, that the mine-laying could not have been accomplished without the knowledge of the Albanian government.
Knowledge was the key. Not actually doing it, but knowing about it.
Precisely. And that knowledge, the court said, created obligations for Albania. These weren't obligations from some specific wartime treaty, but from basic principles. Elementary considerations of humanity, the need to protect freedom of maritime communication, and the fundamental obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states.
So knowing meant they had a duty to warn.
Yes. They should have notified shipping in general about the danger, or at the very least, warned the specific British warships approaching on October 22nd. The evidence suggested they had perhaps a 2-hour window before the first explosion hit the Saumarez, but no warning came. And because of that failure to warn, stemming from their knowledge, the court found Albania was responsible under international law for the explosions, the damage, the tragic loss of life. And therefore, they had a duty to pay compensation.
A really significant finding based on knowledge and failure to act. What about the actual compensation amount? Was that decided then and there?
Not quite. Albania actually pushed back on that specific point. They argued the court only had the power, the jurisdiction, to decide on the principle of liability, not to actually calculate the amount of money owed.
Ah, a legal challenge on the procedure.
Right. But the court looked back at how the case got there. The UN Security Council had recommended a final adjustment of the whole dispute and what both sides had initially agreed to submit. Based on that, the court decided, yes, it did have the jurisdiction to figure out the amount, but they decided to handle that specific calculation in a later phase of the proceedings. So the principle was settled, the amount was yet to come.
Okay, so Albania found responsible due to knowledge and inaction. But as you said, this case had another side to it. The court also had to look at the UK's actions. This involved two separate things, didn't it? The actual passage of the warships on October 22nd, and then that later minesweeping operation.
Correct. Two distinct issues regarding potential violations of Albania's sovereignty by the UK.
Let's take the first one. The passage on October 22nd when the explosions happened. Albania argued the British ships shouldn't have been there without permission. And even if they could be, the way they passed wasn't innocent. What did the court say?
Well, Albania's position was that foreign warships needed their explicit prior authorization to sail through Albanian territorial waters. The court tackled this head-on. It established a really important rule here. States do have a right, in peacetime, to send their warships through straits that are used for international navigation, meaning straits that connect two parts of the high seas without needing prior authorization from the coastal state. The crucial condition, though, is that the passage must be innocent.
Okay, innocent passage through international straits. How do they define an international strait or international highway here? What made the Corfu Channel qualify?
The key factor for the court wasn't how important the strait was, but its geography and its actual use. Does it connect two parts of the high seas? Yes. Is it actually used for international navigation? And the evidence presented showed, yeah, it was used. Something like 2,884 ships had used the channel to get to the port of Corfu over just 21 months in the late 30s. And the British Navy itself had used it regularly for like 80 years.
So even if Albania argued it was just a secondary route.
It didn't matter. The court said its geography and its history of use made it an international highway. Full stop. Now, the court did acknowledge things were tense at the time. There were exceptional circumstances, particularly the friction between Albania and Greece. Greece technically considered itself still in a state of war with Albania. So Albania could issue reasonable regulations for passage in its waters, but it could not prohibit innocent passage altogether, nor could it demand special authorization just for warships to pass instantly. Therefore, the court concluded, the UK did not violate Albania's sovereignty just by sending its ships through without asking permission first.
Right. But then there was the second part of Albania's argument, that the manner of passage wasn't innocent. They pointed to things like the ships being in combat formation, having soldiers aboard, guns ready for action. What about that?
The court looked into each of those claims pretty meticulously. Formation. They found the ships were actually in a line-ahead formation, not some kind of aggressive combat spread. Any real maneuvering only happened after the first explosion, which was obviously necessary then. The soldiers. That turned out to just be the standard Marine detachments that cruisers carried, normal crewing. And the guns. They were found to be in their normal positions for traveling at sea during peacetime. They weren't loaded. The court decided this wasn't inconsistent with the idea of innocent passage.
But hadn't the British Admiralty told them to be ready for trouble, given the earlier shooting incident?
Yes, that's true, and the court acknowledged it. The Admiralty had told the ships to be at action stations, basically ready to retaliate quickly if fired upon again, because of that May 15th incident. The court viewed this as a measure of precaution. Given the history, they felt it was not unreasonable. The whole point of the British mission that day, arguably, was to assert this rite of passage that Albania seemed to be denying. So, considering everything the previous incident, the nature of the precautions, the court concluded that these measures on October 22nd did not make the passage non-innocent and therefore did not violate Albanian sovereignty.
Okay, so the passage itself on the day of the incident was ultimately deemed lawful and innocent by the court. But then we have Operation Retail, the mine-sweeping operation the British carried out a few weeks later on November 12th and 13th. Albania definitely protested that. How did the UK justify going into Albanian waters to sweep for mines without permission?
Yeah, this was a very different situation legally. The UK didn't really deny the basics. They acknowledged Operation Retail happened against Albania's explicit wishes. They knew Albania hadn't consented. And they knew, generally speaking, doing that in another country's territorial waters is against international law.
So what was their defense?
They offered two main justifications. The first was a bit weak. They said they had sort of nominal permission from Greece based on an old mine clearance agreement from 1945. The court dismissed that pretty quickly. They pointed out, well, Albania wasn't party to that agreement, and the channel was primarily in Albanian waters, so Greek permission didn't really count for much.
Right. So what was their main argument? This sounds like where the really big legal principle got tested.
It was. The UK's core defense was about needing to secure the evidence, the mines themselves. The corpora delicti, the body of the crime. They argued they had to act quickly because they feared Albania or someone else might remove the mines, destroying the crucial proof. They framed this as a kind of special situation justifying intervention or self-help. Like, we had to break the rule to uphold justice.
The ends justify the means kind of argument.
Yeah.
How did the court react to that?
Very, very strongly. And negatively. The court's language here is famous. They said they cannot accept such a line of defense, flat out rejected it. They called this idea of a right to intervene, the self-help theory, a manifestation of a policy of force, something that in the past had led to most serious abuses.
Wow, a policy of force.
Yes, they said such a doctrine cannot find a place in international law. They went further, stating that if such intervention were allowed, it would be reserved for the most powerful states, and it could easily end up perverting the administration of international justice itself. Basically, might makes right, and the court said absolutely not.
So even though Albania hadn't exactly covered itself in glory with its lack of warning and cooperation, the court still drew a hard line on sovereignty.
Absolutely. That's what makes this ruling so powerful. The court did acknowledge Albania's behavior. They called Albania's complete failure to carry out its duties after the explosions and the dilatory nature of its diplomatic notes, things that served as extenuating circumstances for why the UK might have felt frustrated and acted the way it did. But, and this is the crucial but, the court said that to ensure respect for international law, it had to declare that the British Navy's mine-sweeping action was a violation of Albanian sovereignty. The court finding the UK violated the law was, in itself, considered the appropriate satisfaction for Albania. The message was crystal clear. International law and state sovereignty are paramount, even when dealing with a state that hasn't fulfilled its own obligations. You can't respond to one illegality with another.
Okay, so bringing this all together, what are the main takeaways for someone trying to understand international law, maybe global politics today? Why does this old case still matter?
Well, the Corfu Channel case is genuinely a cornerstone ruling. It's foundational for a few key reasons. First, it really clarifies how international law can establish a state's knowledge, and therefore its responsibility, even without direct proof, by using strong, corroborated circumstantial evidence. Especially when acts occur within a state's exclusive territorial control. It basically says states can't just plead ignorance when the facts strongly suggest they must have known.
Right, the knowledge principle.
Second, it firmly established the right of innocent passage for warships through international straits during peacetime. No prior permission needed as long as the passage is innocent. That's huge for freedom of navigation worldwide. And maybe the most resonant point today. It delivered this powerful, unequivocal rejection of self-help or unilateral military intervention as a means of enforcing rights or gathering evidence. Even when faced with a serious wrong, the court condemned taking the law into your own hands. It underscored the absolute bedrock importance of state sovereignty and warned against the dangers of a policy of force dictating international relations.
So this deep dive really highlights that balancing act, doesn't it? International law trying to weigh the rights of states, like sovereignty and passage, against the responsibilities they have, like preventing harm and warning others. And as you think about all this, here's something to chew on. In today's world, where getting clear information can be tough, and mistrust between nations is often high, how do international courts continue to walk that incredibly fine line? The line between holding states accountable for wrongdoing and respecting their sovereignty, especially when the basic facts of a situation might be hotly disputed, just like they were here. How do the principles from Corfu Channel still echo in modern disputes over maritime borders, freedom of navigation, and national security actions? Thank you so much for joining us on this deep dive. We really hope this exploration has given you a clearer, maybe more nuanced understanding